All right, everybody, it's about 12, so we'll go ahead and get started. I'm Denny Major. I just realized when I was thinking about the first thing I was going to say that it has been 17 years since I've been at Haynsworth, almost to the day, which is a shocking number to me. And I've spent a substantial portion of that time working on trade secrets and non-compete cases. I do a lot of other stuff as well, but I've had several. I'm a litigator, so I've litigated non-competes and trade secrets cases. I've also, because of that, been involved in helping draft them and also advising sometimes employees who have a non-compete and want to know what their rights are, as well as employers that hire employees who want to know what kind of risks they might be taking when they hire somebody who has a non-compete and work for a competitor. And so in a lot of ways, I've found that to be the most fun part of my practice. And it's been pretty nice to be on both sides of that issue. And probably you'll see that a little bit reflected in this presentation that I don't really take a very strong stance on either side of these things, haven't seen both sides of it. But I'm able to sort of understand what the policies and rationale is for each side. I'm an official member of our employment law team here. You probably, I'm not as involved as some of the others. I'm more of the non-compete trade secrets guy. I try to save all the other boring stuff like FMLA for the smarter people like Katie and Chris and Joseph when I can. So you may not have dealt with me on those kinds of issues in the past. Also, I want to note at the outset that we should score a point for the procrastinators on this presentation because, you know, what I usually would do is probably try to do this presentation the night before or maybe the morning of this presentation, draft it, send it to the marketing people and, you know, kind of do it that way. But this time I had depositions and stuff all day yesterday, a bunch of stuff to deal with this morning. So I on Tuesday had some extra time. I went through and did a presentation, and I think like 5 minutes after I was finished and sent it to the marketing people, I looked it back up again, and the Northern District of Texas issued their order that basically stayed the ban and overturned the new FTC rule. So all of a sudden, my presentation became somewhat moot, although we're going to discuss what the rule, you know, what the effect of that ruling is, what the rule was going to say. But certainly I've been trying to some extent to wing it. And so there might be some places where a slide is a little bit out of place because I haven't had time to kind of go back and organize it to make it make more sense in context of the new ruling. So y'all bear with me on that. Please ask questions as you want. I'll try to look over and get to them when I see them. Certainly at the end, I'm happy to share or to answer any questions. Also, we'll be happy to send slides to you. And if I see a big mistake, I'll try to correct that before we send out the slides. I'm gonna give you, we've got to jump right to it, I think. I mean, there's other things we're going to talk about because at the end of the day, the fact is we're back to the status quo, but I've got to jump right to what happened yesterday. The federal district court in Texas, Northern District of Texas, ruled that the FTC's new non-compete rule was invalid. That ruling is a nationwide, we're going to discuss that ruling in detail at the end and a little bit more about what that means. But at the end of the day, that's a nationwide ruling. So for right now, we're back to the status quo. I mean, we're as if the rule never occurred. Now, it is possible that the FTC may appeal that ruling. I suspect that the FTC's decision, and they may just because of deadlines have to go ahead and appeal, they may ultimately decide not to pursue an appeal depending on how the election goes. So if the Republicans win, you know, that's kind of what happened in 2016, if you recall, with the FLSA rule. There was it was overturned, and ultimately the Department of Labor decided not to mess around with it anymore because Trump was elected, and then ultimately there was a new rule issued under Biden. But that probably will dictate how this is handled in the future. If there is an appeal, the new rule is not going to be effective unless and until the Fifth Circuit Court of Appeals does something. And even then, the Supreme Court, there'd be an appeal to the United States Supreme Court after that. So there may be some delay. I wonder if someone's going to ask this question. It shouldn't really be a big issue, but I've wondered what happens if Susie Brown, employee, decides that she wants to go on September 15th and breach her non-compete, and then her employer brings a case against her. I'm sure she, if I was representing her, I would assert this new rule anyway. And, obviously the court would say, well, it's already been decided it's not effective, and we'd have to go up on appeal. But, what if the United States Supreme Court says, no, Northern District of Texas, you were wrong, the FTC can do what they did, that rule is back in place. Does it apply retroactively again so that she would, be able to use that ruling to say, no, I mean, this was never, that ruling was bad and the FTC rule was effective. That's an interesting legal issue about retroactive versus prospective application type issues. I don't think it's a practical concern for any of you guys, because you just need to act like it, the rule was never issued in the first place. And if I'm advising Susie, I'm advising her, you got to assume that this ruling upholds and that FTC rule is no good. So you're really playing with fire if you breach it. But it's an interesting issue. One other thing I want to note, which is a complete footnote, and I probably should save it until we really start talking about the Northern District Court's ruling. But I'm afraid I'm gonna forget if we don't. I just thought it was kind of interesting. I Googled the judge, who I'd never heard of. Her name is Ada Brown. She's the one who issued the ruling in the Ryan versus FTC case that obviously everyone's talking about, that was issued Tuesday. She's interesting. She's the first African-American female that Trump has nominated, or that he did nominate. And she's also the first in the Northern District of Texas, which is interesting. She's also Native American, member of the Choctaw tribe. She is, I think, a member of Mensa. She started out as a prosecutor and tried over 100 cases to jury verdict back in the early 2000s, and then left and went to a big firm and did a lot of commercial litigation and patent litigation, and tried a bunch of cases there too, which is a really interesting, you don't see that too often. That's an interesting background in terms of her experience. She's obviously very smart. And I say that without getting into whether she's right or wrong on the legal issues. She's just sort of an interesting judge that I'm kind of glad that I went ahead and Googled her and read a little bit about her. But we can go on to the next slide. So here's sort of the outline of, I think, what we can discuss or what we should discuss today in light of where we are. The first is I want to talk about the policies that drive the law regarding non-competes and non-solicitations, really any restrictive covenants. And that goes for state law and federal law. Why are we struggling with these things as we are? And it also helps you understand why the rules, why the state law rules are the way they are, and why the FTC is concerned about them. And, it helps us kind of think about what may happen in the future with these things. And so I'm going to go over how those policies impact and have shaped state law regarding non-competes, and frankly, the FTC's ruling as well. And we're going to talk a little bit about what makes these agreements enforceable. And then we're going to talk about the new ruling, the Northern District of Texas's ruling, and the implications as far as the appeal process goes. All right, and so real quick, I just think this is interesting. It's not very practical, but it's something we all should know and understand. So quick sort of high school government class refresher. I'm not sure I really understood any of this stuff until law school, even though I was a poli-sci major for a while in college. There's a lot of things at play here when we talk about a non-compete rule. The first is federalism. And so within federalism, what we're talking about there is the separation of powers as between the federal and the state government. So if you'll do the next bullet point, yeah. That is, who gets to decide as between South Carolina and the federal government regarding non-competes. Traditionally, it's been the state government, but now the federal government is stepping in. The second issue is this, let's say we're talking about the federal government, if they get to do things, what is the separation of powers within the federal government? Obviously, we have three branches, the legislative, the executive, and the judicial. And all of a sudden, with this new FTC issue, we've seen all of those at play, because that's really what the ruling in the Northern District of Texas, as well as there's been other rulings as well. The Northern District of Texas is the one we worry about the most, because it's the one that has given this nationwide application that has halted this ban. But there are other rulings, and one of them came to a different conclusion. The Eastern District of Pennsylvania, another one in Florida, Middle District of Florida, came to the same conclusion as the court in Texas, but did it under a little bit of a different rationale, which is interesting. At the end of the day, that's what, they're not talking about necessarily whether there should be this non-compete rule, although to some extent the Northern District gets into that. But for the most part, it's procedurally, was this done the right way? Did the FTC have authority to do it? So we hit all these concerns. And until recently, non-competes were really just a matter of state law. I don't think it dawned on anybody to have the federal government start messing around with non-competes, except for lately. And you can go ahead and go to the next slide. So before we kind of get into the weeds of this too much, I want to talk about housekeeping, and I'm about to say this, but I'm probably going to mess it up too. All right. So we talk about non-compete, and also non-solicitations, non-disclosures. A non-compete in its purest form refers to an agreement or a covenant that prevents a worker, or really anybody, from going to work for somebody else or engage in a business, in any form. Like, you can't go work as, for this competitor in a similar job function as you were doing for us, regardless of what you're doing there, really. A non-solicitation, on the other hand, is one that would say, okay, you can go work for this competitor, but you can't go solicit the customers that you had when you were with us. Or sometimes it's, you can't go solicit our employees. And then a non-disclosure is, you can go work, but you can't use any of our information or any confidential information. And so sometimes we get sloppy, and I very much include myself, courts, people, we'll talk about non-competes and kind of use that as a shorthand to also include non-solicitations and non-disclosures. Technically speaking, those are all different. Those are all subtypes of restrictive covenants. So I hope that I won't mess up the terminology, and sometimes I will be guilty of kind of saying non-competes to generically refer to all of those subcategories. But for the most part here, when I say non-compete, I'm really talking about an agreement that prevents a worker from going to work for a competitive business, regardless of whether they're soliciting customers. Obviously, a non-compete is the most restrictive covenant. It's the one that they are concerned about the most, courts, and so it does get more scrutiny. But all of these do get scrutinized, as we're going to see. The FTC rule, this is kind of a leftover phrase. It says the FTC new rule applies only to non-competes. I put that in there before the new ruling. It should say would apply only to non-competes. So under this plain language of the FTC's new rule, as it would have applied, it still would allow non-solicitations and non-disclosures, as long as those were not so broad that they effectively prevented the worker from competing. And so in whether we're talking about state law or the FTC rule or any federal government, anybody's law, there's competing policy concerns about these agreements. So the first is, you've got employers who have invested in their employees and in their business in general. A lot of times it's been years of know-how of learning what to do, what not to do, years of developing customer relationships, of cultivating information. And you let an employee in, And, depending on obviously the level of employment and what they're doing, oftentimes they learn all of this stuff in the process and within a couple of years, and you've been paying for them and the money that you're paying them, they're learning all this stuff. And if they can just go and start their own business, there's a feeling of now you've taken all of this years of know-how that we've given you in a short time, and you're going to use it against us. We're also introducing to our customers. So there is, there's a legitimate concern there that employers have, and having spent a lot of time and money and effort in investment, and then having the risk of it just walking out the door. And then, we also have an interest as society in enforcing contracts that people make. And this is an issue. Presumably, you would like to think that a contract is one that two willing people go into, and that it's reflected in the price of the wages. Now, as the FTC likes to, what in their rulemaking for their new rule, that was one thing they really preyed upon, and I'm not sure they're wrong. A lot of these things are form agreements that somebody signs along with every other document in the world, sitting there in the HR office before they start their employment. Yeah, there's a little bit of truth to that. I think that there's some adhesion issues there. But there is some interest in enforcing contracts that people make that gets considered here. Against those two issues is the employee's right to earn a livelihood and not being stuck in a particular job. A lot of times I'm drafting these things and I'm trying to make sure that they're enforceable for my clients. On the other hand, I've had employee clients who, it's upsetting. This has happened a few times, really. You have somebody who's in a job, and a lot of times it's not a good fit. Their supervisor is difficult, doesn't like them, or, and who knows whose fault it is. But the bottom line is, culturally, they're just not in a good fit. Sometimes it's that they were there longer and there's a new supervisor that comes in and just doesn't work. And the problem is they're kind of stuck. If they've got a non-compete, this is what they've been doing for 5 years, 10 years, maybe longer. And, they're miserable at their job and they can't get out of it. And sometimes, it's that they don't want to risk it. Sometimes, I've had this happen a few times. They'd be willing to risk it maybe because, I may look at it and say, hey, I don't think this thing's enforceable, but you're going to have to pay me or some other lawyer to litigate it for you, which, you really want to do that. But they might say, yeah, I'm that miserable. Well, nobody wants to hire them because the hiring employer is like, well, I don't want to get locked down in this mess. So, tough luck. And so that's a pretty real concern. And then the last bullet point is, just free market principles. I think this kind of goes both ways, but y'all are, I'm sure, familiar with Wealth of Nations, Adam Smith. We're kind of back to high school stuff again, but invisible hand, there's this idea, I guess, on the one hand, that you've got employees, they should be able to go out and compete, and that would drive wages and salary. If I can go to company B and get more, well, company A's got to pay that, or whatever relative to my misery, to keep me. And when you've got somebody locked in, you kind of have them, stuck in a, my guy who's stuck here in this job that makes him miserable. He's got to accept less salary if he doesn't have somewhere else to go. And on the other hand, I guess there's you could argue free market with non-competes as well, and all of the investment people have made. But those are the competing policy considerations that are driving a lot of the problems and the reason I'm talking. And then, the impact that these principles have had on state law is that essentially, they're disfavored. So courts will enforce these covenants, and with the most restriction being on non-competes, but also disfavor and restriction put on non-solicitations and to a lesser extent non-disclosure agreements. I guess it's like parents who, I'm going to let my kid, you can go to this party, but you better behave. You better only drink beer, don't drink liquor while you're there, and gosh, don't ride, don't drive home. We're going to let you have a little leeway here, but we're really going to monitor and make sure that you're on your best behavior, or maybe don't drink beer at all. That's kind of the way I think about the courts trying to monitor these things is we're going to let you do this, but we're going to put a lot of parameters and we're going to look really hard at them. And as a practical matter, a lot of times, you look at these cases and it feels like the court is looking for a reason not to enforce it. And so you better, when you're drafting these things, be really careful about how they're drafted if you want them to be enforced. Now, let's bear in mind, this goes back to what I said a second ago, and I sometimes forget this, but enforcement is important to an extent, but sometimes just the chilling impact that one of these agreements has is enough to begin with. So, like I said, I may look at a non-compete, and I've got one now, where I looked at it, I was like, this is like the worst non-compete I've ever seen. The company that did it is from somewhere, they're not even a United States company. And I looked at the thing and I was like, this is like, I mean, it's laughable. Like I would get in front of any judge, even one that has no idea what they're doing, and they would be like, oh, this is terrible. But there's still a chilling effect of, well, I mean, I can never guarantee you. And also a hiring employer is like, I don't even want to deal with that problem, And so that being having it narrowly tailored isn't always the goal of an employer. If they think that I can, maybe this thing's not being enforced, but if I can scare the employee from doing this or scare a hiring employer from hiring this person, I've solved my problem. So like I said earlier, non-competes versus non-solicitations and non-disclosures are the most disfavored, and they're the most difficult to enforce. They're the most disfavored because they're the most restrictive, right? I mean, you can't go work, you can't go do this type of business, you can't go work for this company. Because of that, they have an additional restriction that a non-disclosure and a non-solicitation doesn't have. They have to have a geographical restriction. And so a lot of times you'll see a 30-mile radius. Sometimes it's a 30-mile radius of where the employer does business. Sometimes it's like an area where the person's made contact with customers. There's different ways to skin the cat. But the problem is, with technology and changes in the way that we work, if for a lot of businesses, I find it really hard to draft a non-compete that has a geographical restriction that I think is enforceable and also protects the employer. And some of it is just the way that things have evolved over time. I mean, we used to be so brick and mortar. So you read most of the early non-compete cases, and really most of them are early non-compete cases, and it's a vet clinic or a doctor's office, or and there's 5-mile radius, and from Greenwood, South Carolina, or whatever, where everything's out in the country. I mean, you see the flavor there, but the problem is you've got judges now trying to apply those old principles to the way we work now. And as a lawyer drafting these, you're trying to navigate that problem. But if you put it too narrow, it's meaningless, because the person's got customers in California. I mean, they can go sit 10 miles away and work, and it really, a 10-mile radius isn't any good. It's hard to draft those. And so I have found, and this is not true across the board, but for many types of employees and for many businesses, especially employees that are sales employees, which I find are kind of the scariest ones to go anyway. A non-solicitation a lot of times it's easier to draft. Let me put it that way. And it has a lot of teeth, and really has probably more protection. And then I could talk all day about non-disclosures and trade secrets, because they're this afterthought sometimes in these cases at first. Everyone's like, oh, we can just get this non-compete thrown out, or this non-solicitation is unenforceable. And yeah, that's great. But my gosh, if you've got an employee that took documents, that is going to come out, and that litigation is so expensive to litigate. I mean, the discovery, once you've got any information indicating that the employee has taken something, the discovery in those cases is so expensive. And then, you've got to convince fact finders that, hopefully that the information isn't really a trade secret or isn't helpful. But I mean, you got a lot of uphill battles there. So there was a verdict in South Carolina in the district court here in Columbia, just down the street from me. I was monitoring this case, actually went and saw some of the trial. It was $96.5 million. And, from what I saw and just I had a lot of conversations with the attorney for the defendant, she did an excellent job in that case. It's eye-opening because they got the non-compete and the non-solicitations thrown out in that case. The jury didn't even know they existed. And you had a $96.5 million on misappropriation of trade secrets. So, there's a lot of, if you're a hiring employer, that's a monster, that you shouldn't forget about. And I've been hired by people that are about to hire competitor employees sometimes just to help them navigate, the process of not, inadvertently or intentionally taking information. Because sometimes you don't even mean to take it, but you've got it and it just creates a lot of problems. So we can move on from that, but I did want to mention that. So this is, I'm giving you the general requirements for enforceability. This is state law, okay? I want y'all to remember that. And this is what is in effect now. It's what was in effect before. And so this is really where there's been no change. But to be enforceable, non-competes have to be supported by valuable consideration. They have to be necessary to protect the employer's legitimate interests. They have to be reasonably limited with respect to time and place. So, it's got to be 2 years. I really don't like going beyond 2 years if I'm an employer. Anything beyond that makes me nervous. Place is the geographical restriction that I mentioned. It has to be not unduly harsh or oppressive, and basically in preventing the employee from earning a livelihood. It has to be reasonable from the standpoint of public policy. So a non-solicitation is the same as those factors, except that you don't have to have the territorial restriction, the geographical restriction, if it's otherwise properly tailored. And that's why I say for many types of employees now and before the FTC ruling, and even if the FTC rule was still in effect, whether it is or isn't, non-solicitation is often, I think, from an enforcement standpoint, more, I have a lot more confidence in non-solicitations being enforced for the most part. I certainly like drafting them more, because the geographical restriction is such a monster for a non-compete with the way we work now. And then for non-disclosure agreements, I think it's the next bullet point. There's separate requirements, and we'll go through those just briefly in a second because it's not, I think I need the slide to go explain that. So some common pitfalls that I see, and I'm not, we could sit around and do a lot about how to draft a proper non-compete, but I would say this is the most helpful external psychological thing to do if you're, really probably ought to get a lawyer, and if you do, get one that has experience. Don't just get a general practitioner. Get somebody that's got experience in these things. So what I do when I look at these, whether I'm drafting one, usually somebody's giving me a form or something. It's very rarely from scratch. I'm modifying it, but or if I'm looking to see if something's enforceable for a hired employer or an employee, I think about an absurd example. Okay, like a lot of people call it the janitor rule or the landscaper rule. And so one thing I see sometimes people just forget to do is it'll say something like, let's say you've got a veterinarian, it'll say the veterinarian can't go work for a competitor. Well, that's it. Even if it's got the right time and place restrictions, that's going to be invalid because it would restrict the veterinarian from being a janitor or a landscaper or something like that for a competitor. And there's no legitimate reason. That is too broad. And I think it's more, I don't think they're trying to be that broad. I think somebody who drafted it made a mistake and forgot to have that restriction. But, when I'm looking at it, I can just check. I've got a little checklist in my head and I go through and I think of examples and I can just check that off. That's going to be invalid because of that. There's a case or two on the site. Another one is obviously geographical and time restrictions being too big. Again, geographical is so fact specific. I can't even begin to give you guidelines. It's so dependent on business, the particular business and the particular employee, what their job duties are. time-wise, that's going to be tied in with some of the other stuff, how narrow the other things are. Uh, I, you know, 1 year I feel really good about. 2 years I feel okay about. Anything past 2 years I get pretty nervous about. I'm not saying they never enforce 3 years, but I just start to get pretty nervous. And then for non-solicitations, a big issue, and this is not the clearest um, law in South Carolina, but there are some cases that or some authority that would suggest that they really need to be limited to customers with whom the employee himself had contact. So if you just say, okay, you can't solicit any of employers' customers for purposes of a competing business. That's not be good because that's beyond the customers with whom the employee had contact. Or you might be able to get away with limiting it to customers for whom that employee had access to confidential information. I still get a little nervous about that because I'm not aware of a case in South Carolina that directly says that's okay. But that you might be able to get away with that. Certainly, you can't make it all of the employer's customers. And also, sometimes they'll just say you can't solicit the customers with whom you had contact, and they forget to say, for purposes of a competing business. Well, you don't have a legitimate interest if you're a veterinarian clinic from, telling your employee that they can't solicit the customers for landscaping work and they move to a new thing, because that's not even, they're still going to go to you. So you don't have a legitimate interest in there. Sometimes they mess that up. And then for non-disclosures, if you define confidential information too broadly, that can be a real concern. If we go to the next slide, there's some examples that are it's easier for me to show you. So there's one, this is a 1996 case called Muck and Fuss. Maybe to some extent it got overruled by statute, but I don't think it did for this proposition, which is, in that case, they defined, they said you can't use confidential information. I think maybe I can't remember what the exact term, but they defined it as any knowledge or information concerning any process, product, or customer of the corporation. You can read it right there. I won't just read it, but it didn't limit it, to information that is, not generally known, by the competitors or the community, and therefore, you define it so broadly. This would, in effect, keep the employee from working. I mean, he couldn't go to a competitor and without doing this, and so because the court found that that no employee would be able to go to a competitor without using this information. Therefore, you had to treat it like a non-compete. And the problem was it didn't have a geographical restriction or a time restriction, so it got thrown out. And then the next slide is a similar case. It actually discusses that Muck and Fuss case. It's a district court case. Similar thing here. They define the confidentiality as all inventions and all other business, technical, and financial information. At the end there, they have a subcategory of all confidential information, but that's not, there's more than that. And therefore, the court said, well, that's way too broad again. That's effectively a non-compete, and they threw it out. The problem, if we go to the next slide, I think it's got it. Yeah. So the problem with both of those cases was they were using generic categories of information, but they weren't saying first, so the way I would normally do it is I would define confidential information to be, information that you learned during your employment that is confidential and not generally known to competitors and is important to the company or something like that. And then say, to the extent consistent with the foregoing, it may include the following, and then you can list categories. But you can't just say that those generic categories are the confidential information, because they may not be confidential. And in a lot of times what you're going to find in discovery is they aren't, because somebody's just sending them out, and half the time it's stuff on their website and anybody can get. There's all these absurd examples. So that's the biggest risk of the non-disclosure. The next bullet point, I think, yeah, so this is an example of a definition that was upheld. That was actually a case that upheld it. I usually tie my definitions kind of close to that, just because I know that that one's going to be okay. Next slide is tips for non-solicitation covenants. We talked about this a little bit with the pitfalls, but again, I think the most common one now is I like to see it limited to customers with whom the employee had contact, or at least had access to confidential information at the employer. Probably, I mean, it's clear that if you do that within 12 months of employment, that's good. I would do it 2 years. If it's something where the employee's been there 10 years and you don't have that limited, that starts to get me a little worried. What if you had contact with a customer 8 years ago? Is that really a legitimate thing to prevent them from having it? Probably not. So I would limit it to contact within the final 2 years. And then again, having a restriction as to the purpose of the solicitation. Sometimes I think people just forget to put that in there, but I see it, and if I'm hiring employer or the employee, I'm pretty happy, and I'm like, well, it's pretty clearly not going to be enforceable. If I'm trying to enforce it, I'm immediately scared of like, well, who drafted this? Gosh, I feel bad for that lawyer that's about to tell his client that that their thing is unenforceable. And so on temporal restrictions for non-solicitations, I tend to see 1 year most often. And I'm not saying 2 years is too long, but I see 1 year so frequently I get a little nervous if I start seeing 2 years. So I would just be careful about that. The other thing is it's not very clear at all that the courts would enforce an agreement as to prospective customers or former customers. And in fact, there's a couple of trial court orders out there where the court has struck an agreement or a non-solicitation that kept the employee from soliciting prospective customers. If you're going to do that, you ought to have it in an entirely separate covenant, like in a separate subsection, so that the court might just strike through that rather than refusing to enforce the one as to the actual customer. Again, that's another reason why getting a lawyer that understands these covenants and also understands blue penciling, what a court is going to do when a court may strike part of an agreement. That just the formatting of the thing itself can make a difference for that. So it's important to get somebody that knows what they're doing to look at those agreements. And y'all, this again was something that was something I was going to talk about a lot, regardless of what the FTC rule, if it was in effect, because non-solicitations were still good, non-disclosures were still good, regardless of the FTC rule. So that was going to be really important. And I just don't think that, other than for chilling effect, that for most employers, that the FTC ruling really changes the world much one way or the other. I think it maybe changes it just for the chilling effect more than anything else. So me talking about non-competes and what's enforceable is a little bit, it's also so fact specific with those. It's really hard for me to give you very good guidelines. And so that's why my tip on non-competes, that's all I can tell you, is you really ought to get a lawyer who understands the non-compete and can tailor it for each specific employee, or you can put something in there that's probably unenforceable, as long as you understand it's unenforceable, and that maybe the only thing it's doing is scaring an employer or a hiring employer from hiring that employee. And so no blue pencil. This is what I just talked about. So just to reinforce, I want everyone to really understand the court is not going to rewrite in South Carolina and in a lot of other states, not all. Some states, a court will rewrite a restriction. Like if they say, okay, well, 60 miles is too big of a radius, but 30 miles would be okay, they'll actually rewrite it. In South Carolina, that is not the case. If you have a restriction that's 60 miles and the court thinks 60 miles is too much, that non-compete is unenforceable, even if the employee is operating next door, which clearly would be enforceable if you drafted it that way. So you get, you kind of get one shot, and there is such thing as like step down covenants where sometimes they'll say, well, if this is unenforceable, then this. Maybe those fly in South Carolina. We could talk about those all day. I won't get into them much, but otherwise, you really have to, if you're going to wind up trying to enforce this thing, you really need it pretty narrowly tailored. You don't want to overdo it. So next slide. All right, so that all is state law. That rule was always going to exist. I guess if non-competes were no good, the non-compete part of that was going to kind of become moot, but state law still applies. It applies now. State law regarding non-solicitation and non-disclosures was going to apply whether that FTC rule is in effect or not. But all of a sudden, we have the federal government stepping in. Up until like 2018, nobody even thought about non-competes federally. It was all state law. And so recently, starting about them, maybe it's like 2021. There have been some federal efforts to move into this arena, and we'll see those if we go to the next slide. So timeline-wise, yeah, so okay, Biden issued an executive order in 2021. I think there was something that happened in 2018 too. I think maybe somebody introduced some bill or something, but I'd have to go back. But in 2021, Biden issued an executive order that really, it just said federal agencies to try to figure out something to do with non-compete. It didn't have any real binding effects or anything, but it's sort of a sign of what direction it's heading. And then in 2023, as y'all know, at the beginning of 2023, the FTC proposed the rule that banned non-competes that we're going to talk about in a minute. Just to put some other context, February 1st, 2023, a group of senators, and I think they were bipartisan, introduced the Workforce Mobility Act. That was, I can't remember all the provisions, but it was they're going to ban non-competes. I have no idea. I don't think that's ever gotten anywhere, but just worth noting that there's these efforts. In May of 2023, the National Labor Relations Board General Counsel issued a memo that basically said that non-competes would violate the NLRA. Now that's non-binding. That's just sort of gives you an idea of what the NLRA, I mean, what basically what they're going to try to do enforcement wise. It's not, doesn't mean that NLRB is going to view things that way. Also, it has limited application that, the NLRA doesn't apply to anything, or it doesn't apply to supervisors. So, it's not that it has some huge application, but again, we're seeing this trend. And then on April 23rd of this year, the FTC announced their final rule. And then on August 20th, so Tuesday, that was the Northern District of Texas order that we're going to talk about. So let's talk about the new rule that was issued. So let's put it in context. The FTC, y'all probably know, the Federal Trade Commission. It was organized in 1914, and there's certain sections within the Federal Trade Commission Act, Section 5 and Section 6, are kind of the ones that have been at issue. And so, I for the life of me, I did really well in administrative law when I was in law school, but I swear I've never really understood any stuff. I'm not sure anybody does, but the FTC in general is not, they're like any agency. I know y'all deal with the Department of Labor a lot, but they're not supposed to go outside of the powers that Congress gives it in a statute. And that, at the end of the day, is kind of the crux of the issue that the Northern District of Texas and other courts are dealing with. Next slide. And so just as an aside, if y'all are really nerdy like I am and you're interested, it's going to have no good practical application for you. But this is kind of one piece of the puzzle of a lot of academic literature and case law that's developing regarding the role that agencies play in our government. If you get back prior to the New Deal, agencies just were not much of a thing. And ever since then, it's kind of been this big creep of now everything's agency and regulations. And there's some interesting viewpoints on that, very academic, but just wanted to kind of throw that in there in case anybody's interested. You can Google it and get a good start to that kind of stuff. So next slide. So the FTC final rule, put in that context, you've got to have this, FTC's got to have this authority and all. So what it does, or what it was going to do, it was going to apply to just non-competes, as we said, and also de facto non-competes, which we're going to discuss what that was going to mean. We kind of already touched on it, but it was going to invalidate, which is interesting, any existing non-competes, unless that person is senior executive, and would invalid, even in the future, there could be no future non-competes past September 4th as to the senior executive. Any breaches prior to September 4th would have been actionable then. And so the way that it read was it would prohibit and push from entering into or trying to enforce a non-compete clause, except for enforcement of a non-compete clause for a senior executive that was entered into before September 4th. And also representing that somebody was subject to a non-compete clause unless that was a non-compete clause for a senior executive prior to September 4th. So you weren't even allowed to say it. In fact, there was a notice requirement that you had to notify the employee that they were no longer subject to it. And so here, I put in here a verbatim definition of non-compete clause. It's basically any clause that prevents the worker, or penalizes the worker, or functions to prevent a worker from seeking or accepting work with a different person. So basically what we said earlier when I was defining non-competes in the terminology. And that could be oral too. It didn't have to be a written provision. And so, yeah, that's basically what I just said. Next bullet point. I thought it was worth noting this applies to clauses by the words of it. So, if you had an agreement that had a whole bunch of stuff in there, including a non-compete clause, the way I read this is it wouldn't invalidate the entire agreement. It would just invalidate that clause. And then I thought it was interesting. So the commentary that the FTC gave, forfeiture for compensation, that's when, okay, you can go compete, but we'll pay you for, for when you don't compete. And it said those are invalid, which, they're just as bad as any other non-compete clause. And then de facto non-competes, those are ones that function to prevent. That means like an overly broad non-disclosure, like what we looked at in the Muckenfuss case and that Newport versus Bell case, where they define information so broadly that you really would restrict the employee from competing. The court would view those as a non-compete as well, even though on its face it'd be a non-disclosure. So senior executives, just real quick. I mean, again, the only distinction here is as to existing agreements prior to September 2024. I mean, I would have gone into this more, but with the court's ruling, there's not a whole lot of point. In some, and this is case by case. I mean, I'd have to look at the particular employee. There's the salary requirement of 151, 164, but they talk about policy-making authority. I think as a general rule, I'm thinking C-suite employees is per se senior level executive, and after that, you're going to have to make a little bit of a showing. It's sort of the bullet. It's sort of the nutshell version of the senior executive. The next slide. The notice requirement I talked about earlier, there was a mandatory, you must provide this notice. Who knows what I mean, I guess the punishment would be some sort of fine. I don't know if we're clear. There was model language for the notice. You don't have to worry about it now. This new ruling, at least for now, until something changes with a different ruling, there is no requirement to send this notice out. De facto agreements. That's what we already kind of covered that. I probably should have put the slide back thing before. But one other thing I didn't mention, they talk about in the comments, training repayment agreements. They would view that as a de facto non-compete. That's an agreement that requires the worker to pay the employer a third party for training costs if the work terminates within a specified time period. If it's not reasonably related to the cost the employer incurred. So I thought that was interesting. That was also a de facto non-compete in the FTC view. But again, we don't have to worry about it at this point. I'll take a second. There's a question. If there's non-compete form signed by an employee, if there's no geographic location mentioned, is it still valid? Yeah, I mean, if it's a non-compete, it's not going to be valid. Now, if it's a non-solicitation, might be okay. But yeah, you're not in South Carolina. Maybe other places. And I hate to say anything's absolute, but I mean, I guess if you could show that no territorial restriction was required because something very compelling about this employee's work, you might be able to get away with not having a geographical restriction. But as a practical matter, I mean, I've never seen a South Carolina court even sniff at enforcing a non-compete without a geographical restriction. Next slide. All right, so the challenges that have been made, I wanted to start with the Eastern District of Pennsylvania. So this is the ACS Tree Services case. That court held that the FTC does have authority to issue substantive rules. Like it was within its bounds of doing this FTC non-compete rule, and it upheld the rule. And then the next bullet point has a whole lot of language that I quoted. The italicized stuff is all quote. And then there's quotes within the quote. But I put in the bold stuff, nothing in Section 5 or Section 6, which is part of the Federal Trade Commission Act, expressly limits the FTC's rulemaking power to issue exclusively procedural rules. And then when taken in the context of the goal of the act and the FTC's purpose, the court finds it clear that the FTC is empowered to make both procedural and substantive rules as is necessary to prevent unfair methods of competition. That's a federal district court judge who has the same authority as the other one that we're about to talk about. So just to show you the difference in opinion. So the next slide. This is the Middle District of Florida's ruling that was August 14th, so about a week ago. So this is a little bit interesting, and I haven't really studied this opinion, I just haven't had time, but this court held that it violates the major questions doctrine, which I think might be like kind of a separation of powers constitutional issue rather than an Administrative Procedures Act authority issue. But I thought this was kind of interesting. It's a little bit different rationale. That court, so it ultimately held the FTC's rule was invalid, but it limited its ruling only to the parties at issue and declined to issue any kind of nationwide rule. Next slide. So this is the big one. This is the one that y'all are aware of. It's this Ryan case that was the one that Judge Ada Brown issued the ruling in. Initially, she granted a preliminary injunction. I think back in like July, might have been in June, might have been early, I can't remember. But then at that time, it only applied to the parties in the lawsuit. And we knew that this was coming before August 30th, and that she would make a more final ruling. And so next slide, on yesterday or Tuesday, we got that ruling. The court granted summary judgment and set aside the FTC's new rule. Explicitly held it shall not be enforced or otherwise take effect on September 4th, 2024 thereafter. It applies nationwide. And so I wanted to show you, this is quote from that opinion. The issue presented is whether the FTC's ability to promulgate rules concerning unfair methods of competition includes the authority to create substantive rules regarding unfair methods of competition. Remember, I mean, that's what the Eastern District of Pennsylvania, that's exactly the issue it was dealing with. It's just that this judge came to a different conclusion. So next slide. And so the court gets, I mean, I'm not going to sit here and read the opinion to you, but the court engaged in an analysis first by looking at the text of the Federal Trade Commission Act. And you can see what it concluded, that it does have some authority to promulgate rules, but it says after reviewing the text, structure, and history of the act, the court concludes the FTC lacks the authority to create substantive rules through this method. And it talks about, so the big issue was this Section 6G of the Federal Trade Commission Act. That was what the FTC was hanging its hat on. And it said, this court, Judge Brown, said, well, this is only a housekeeping provision, not something that is substantive. Next slide. Interestingly, the court, aside from just looking at the text, it looks at the location of where that provision was in the act itself. It's just one of many, and so it's kind of like you wouldn't just throw in this huge, broad authority in the middle of all this other stuff. Is effectively what she's saying there. And then, interestingly, she looked at the history of the Federal Trade Commission and the act. I mean, she said, but FTC, you guys didn't do a damn bit of substantive rulemaking and disclaimed authority to do so for the first 48 years that you were in existence. And then also, you didn't do a damn thing with this Section 6G between 1978 and 2024. So now all of a sudden you're telling me you have all this authority? Like, I don't think so. That's kind of what she's saying there. She looked at the legislative history. I wasn't able to read this part of the opinion in too much detail, but what was the reason for the passing the act? What was the amendment, the reason for the amendments and that kind of thing? Next slide. In addition, so we got the authority to do it was the first rationale she gave. That, you didn't have this authority. And then as a separate independent basis for her ruling, she said that the non-compete rule is arbitrary and capricious because it was so broad without like a reasonable explanation. You didn't look into alternative restrictions why did you choose such a broad restriction, such a broad prohibition, and you're not explaining to us why you did that? I mean, don't get me wrong, there's 100 pages of this rule. If you guys are just really, really nerdy, I mean, I'm very nerdy and geeky, and I think I would rather listen to a Nickelback album than have to read that entire rule making. It's so boring. So there is a lot of stuff in there, and apparently Judge Brown went through it and said, really, it's not rationally connected to the rule that you made, which I'm just not willing at this point in my life to go back and see if I agree with that or not. It's too much for me to read that stuff. So, but importantly, that is an independent basis by which she has struck that rule. And so next slide, I just quoted this stuff. I quoted the last thing because it's kind of a summary of the opinion. Having concluded that the FTC promulgated the non-compete rule in excess of its statutory authority and that the rule is arbitrary and capricious, the court must hold unlawful and set aside the FTC rule as required under Section 706, which I think is like the Administrative Procedures Act. And then she goes on to explain why she's doing nationwide effect. She quotes another case that says that setting aside an agency action under Section 706 of the Administrative Procedures Act has nationwide effect. It's not party restricted. So that, I'm telling you that to kind of reinforce this nationwide idea. That doesn't just apply to those parties. It doesn't just apply to people in Texas. It applies to everybody. You guys might have heard the phrase, maybe not, I've heard it before, where they say that the most powerful human being in the country and perhaps the world is a United States District Court judge. And I think, I mean, I've never asked why people say that, but I think this is it. I mean, they have a lot of power to strike something down. Now, their ruling is appealable and can go up and get overruled, but that takes a while for one thing. And if you really had a crazy judge, you could do a lot of funky stuff to keep getting around those, might get sent back down, and then there's a different, I mean, you could really kind of get into a world of crazy. So these judges have a lot of authority, and that's what this judge did. And then the next slide, I think, is just kind of a recap of where we are. Man, I wanted to go through this rule. It is possible it will come back, and I don't know. It's hard for me to predict. I've been wrong about those things before, about whether they'll be upheld. So I'm not going to predict. I guess the Supreme Court is, somebody might look at it and say, well, they're kind of conservative. But this doesn't quite go party lines exactly. I'm not sure, to some extent it does, but it would first go to the Fifth Circuit Court of Appeals, which is where it's got Texas and Louisiana and maybe some other state on it. But then it would go to the United States Supreme Court. Those other cases would also go up, the Eastern District of Pennsylvania, Middle District of Florida. There's probably other things out there pending. Those all could go up, and the United States Supreme Court might take all of them and issue one ruling. Again, the election is going to make a difference in what happens, because if Republicans, I mean, Trump may get elected, and I don't know. I don't follow any of that stuff. I don't look at polls. I don't know anything about that. But I know that there's an election coming up, and I know that in 2016, the Department of Labor just abandoned that FLSA rule. That very well could happen again. The FTC just decide, well, we're not even going to challenge it. But again, I know everybody's been so excited about this rule. And usually I bore people. I love giving presentations on non-competes, and nobody else likes them. And all of a sudden people are interested. And I'm like, it doesn't really. I mean, I've never seen a non-compete that I really thought was going to be enforceable, or very rarely. And I just don't know that in terms of enforcing them, that it makes that big of a difference. But I do think, practically speaking, the chilling effect that those things have does make a pretty big difference. And so I see that. But, we're back to the status quo for now. There's nothing you need to do differently. You can just act like you've always been acting and move forward. So, I think that's about all I have to say about that issue. I'm happy to, anybody wants to give me a call and discuss, I'm happy to discuss it with them. So I don't think we have any other questions. I think there's one comment in there. So somebody accused me of delivering something in an understandable way, which I must have, I guess a blind squirrel will find an acorn every now and then. But anyway, good luck. And if y'all have any questions, feel free to give me a call.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.